This content is brought to you by iTrust Capital, which is a great platform that allows you to easily invest in crypto without worrying about taxes or fees. iTrust Capital allows you to invest in crypto through an individual retirement account or IRA. IRAs are tax sheltered accounts, which means all of your crypto is tax free and can even grow tax free over time. The process of signing up with iTrust Capital is very easy. They have a mobile app. They have 25 plus cryptocurrencies. They have full support, a dedicated team ready to help you. And it is free. And once again, 100% free to sign up with iTrust Capital. There are no hidden fees and there's no monthly subscription or membership. They also have great security. They utilize Coinbase custody for all their custodial services. So you don't have to worry. It is institutional grade crypto custody that they are using. This is a great platform. Once again, it is free to sign up. So visit the link in the description and go check it out. If you sign up with my link, you get a $100 funding bonus. So once again, check the link in the description. Welcome back to the Thinking Crypto podcast, your home for cryptocurrency news and interviews. With me today is attorney John Deaton, who's no stranger to the show. John, great to have you back on.
Thank you for having me, Tony. I appreciate it.
Well, John, I certainly want to speak to you because you recently filed a motion letter asking the judge within the SEC versus Ripple lawsuit to let you write a brief on behalf of the 67,000 plus XRP holders. Can you tell us everything about this, why you decided to do this, and what is the goal that you're trying to achieve?
Okay, so just to bring everybody up to date, the judge, when I filed way back when I filed a motion to intervene, asking to be named defendants along with Ripple. But in the alternative, if the judge didn't grant that, to grant us what's called amicus status. And, technically, it's just the individual XRP holders who filed the motion to intervene. A lot of people remember the judge said, and Ripple objected, and the SEC objected, and said, well, we don't want to go through this class certification because it could delay the case. So the judge said, that's fine. I'm going to grant amicus to these individuals in their individual capacity as XRP holders. But that's neither here nor there because the 6 XRP holders share the same interest as the 67,300 and some XRP holders. And so the judge basically said that she will allow me to participate on certain issues that she grants approval about. And in her original decision, she stated, quote, especially with issues that are dispositive in nature. Now, what that means is basically, typically speaking, it's going to be summary judgment, right? That we're going to be allowed to write a brief as it relates to summary judgment. But she also said that she could grant permission on other issues, either by me requesting it or by her sua sponte on her own saying, I want to be heard by the amicus. And what I learned behind the scenes, now that her decision on scheduling order has come out, and she said, Daubert motions are going to be filed in July and responses in August, and summary judgment will be September and replies in December. So I reached out because I don't know what's not in the public record. I can't, just because I'm amicus counsel, I'm not a party. So I can't see what's been shared between Ripple and the SEC unless it's in the public record. And of course, some of the things in the public record are redacted. So I don't get to see any of those things. And so I just reached out. I knew that there were a total of 16 experts in this case, right? And I didn't know which kind of experts, except for the one expert. There's a report that's filed in the public docket by Dr. Metz, right? That's the only expert I knew about. So I was just communicating with the parties asking, hey, you know, is there other areas that I could participate? And through that process, and just for the record, Tony, I'm only discussing what's in the public record. I filed this letter and it has exhibits, so I'm not going to get into anything that's not within the public record that is available to everyone today by just going and pulling what I wrote and everything. And basically I learned, and I suspected that the SEC might be using an expert who might discuss XRP holders, because I went to the Telegram case and I looked at the summary judgment that was granted against Telegram. And Telegram used an expert witness called Patrick Doody. And basically Patrick Doody offered opinions and testimony as to what reasonable Graham purchasers relied upon when acquiring XRP, what their expectations were. And his ultimate opinion in the Telegram case was that the Graham purchasers were entering into a common enterprise with Telegram, and they were relying on the efforts of Telegram to generate a profit. He made statements that there was no use cases for Telegram, for the Grams, right? It was only an investment. You couldn't use it in any way. And so the only thing that they could rely on was the promises and the inducements made by Telegram to get them to buy the Gram token. And so XRP and Grams, as you know better than anyone, Tony, are two very different tokens, right? Completely different facts. Telegram is an initial coin offering. The blockchain had not been created yet. They were using the funds from the Gram purchasers to build the blockchain. Completely different facts. Yep. But I'm just trying to find out, hey, is there something that I should know about as an amicus? Like, I don't want to find out after the fact. And in doing that, I learned that Patrick Doody is an expert witness in this case, in the Ripple case, in the XRP case, and the SEC is using him, and he's given opinions. Now, I don't know exactly what he's saying because I haven't seen it, but he's given opinions and offering opinions as to what you or I or the individual 6 XRP holders who represent amicus, what we relied on or didn't rely on or things like that, right? Because I learned from Ripple's attorney, again, this is public information, not private conversations. It's in the exhibits that I attached, that there is a report by Mr. Doody, and he does offer opinions about XRP holders and what we relied on or we didn't rely on. So I was simply saying, can I get a copy of that? Read it, and then I can decide, do I go to the court and ask for permission to see that? And what we learned was that Ripple said they were willing to give it to us because the SEC did not designate Mr. Doody's report as confidential. But they have to give notice to the SEC that they're willing to share it. Well, when the SEC found that out, they designated it confidential, right? Basically tying Ripple's hands. Ripple can't then share it, right? And so I agreed to only use it for litigation purposes and to be bound by the same limitations. But the SEC basically said to me, Deaton, you haven't sought permission and it hasn't been granted by the judge for you to participate. And we're not willing to share with you anything because you haven't received permission from the court. So based on all of those facts, I went to the court and simply said, can I have permission to participate in this motion related to this expert witness named Patrick Doody? And I argue that arguably there's no more singular issue that she should hear our perspective, because he's allegedly testifying as to what XRP holders did or didn't do or didn't rely on. And so I want to be heard. That's basically it in a nutshell. The only other thing for your listeners to know is that it's called Daubert, and that's from a U.S. Supreme Court case. And what that does is it established certain minimum thresholds that an expert witness must meet in order for the judge to determine that witness is a credible, qualified expert witness, right? And that their opinions should be heard. When someone makes a Daubert challenge, what they're saying to the court is that, judge, you shouldn't hear and accept these opinions because the methodology that underlies these opinions is flawed, right? So apparently Ripple may be challenging, and I believe they are challenging Mr. Duty's opinion and saying that it's unreliable and shouldn't be accepted by the court. And they may be challenging Dr. Metz, about price appreciation of XRP tied to Ripple announcements and things like that. That could be being challenged as well. I'm not asking to be a part of any of that. I'm just saying, and I'm not asking if Mr. Duty is going to say that when Ripple sold XRP to somebody directly, if he's offering testimony like that, I'm not participating in that. I'm saying to the court, if this expert is going to offer what XRP holders were thinking when they purchased XRP in the secondary market, completely independent of Ripple,
right,
we should be heard. That's it in a nutshell.
And that absolutely makes sense. Make sure that he's done his due diligence. And I'm not surprised the SEC is fighting this. And I know in the past we've talked about how my mother, my mom, she has some crypto, but through me, and she doesn't know what the hell Ripple is. And she's just like, hey, is it up? That's a question I get asked. And I'm sure there's a lot of people, down that avenue. And there's been a lot of studies showing altcoins move with Bitcoin. And it's very true throughout different bull cycles.
Well, listen, as you know, we have now, it's grown. Each day it grows. A few more people sign up. But as of today, it's like 67,370, I think it may be up today, XRP holders who have joined in this notion of, hey, we're all in the same boat about what we expected or didn't expect. For example, I don't know if Mr. Duty is going to say that an XRP purchaser who acquired XRP, that they were relying on some kind of, something on Ripple's website. Let's pick something, right? Or some kind of announcement that Ripple made. Well, if the majority of XRP holders who purchase it for the first time, if they're unaware of a company called Ripple, then they're unaware of the website, right? You can't rely on something if you didn't see it or read it. So if you don't know about a company called Ripple, you don't know anything about what they're doing or anything like that, then how do you rely on them? So I don't know what his answers were to those kind of questions, right? For example, did he interview XRP holders? How many did he interview? Did he'd ever call John Deaton, who represents 67,000 plus? What is the basis for his opinion about what you or I or your mom or anyone else relied on. Now, also remember, in the Telegram case, he offered opinions that there were no non-investment reasons to buy the Gram token. And that might be true. That might be true with the Gram token, right? But that's not true with XRP, because I have thousands of people who have said that they go on the XRP ledger itself and they use XRP to purchase casino coin or locks or other fiat, and they move it. They move Bitcoin on the XRP ledger and they use the XRP as a bridge or transfer asset, you know? And so there are reasons, YouTubers such as yourself who have been tipped XRP. Yep. Well, I think you and I talked, you may have used XRP that was tipped to you for providing great content, yep, and then purchased a microphone or purchased headphones or purchased something that allows you to continue your, you know, business activity, if you will. Well, that's a non-investment reason. When someone tipped you XRP, you didn't acquire that XRP to hodl it and to invest in it. You used it as a substitute for fiat currency to make a purchase, right? Yep. So that's an example. Did he take into consideration those types of instances for non-investment uses? And, you know, one thing I tried to point out to the court was that, you know, Ripple was willing to give us the report and said in the exhibit that I attached that, you know, you may have something to say here, Deaton, as it relates to XRP in the secondary market that is different from what Ripple thinks. Sure. And so what I did is I reminded the court that she actually, when she granted it, I reminded her that she stated, quote, that XRP holders may view XRP differently from defendants and thus may stress arguments differently. And then I added a footnote, and Jeremy Hogan was entertained by the footnote 3, because what I wrote was the court's perception is accurate. For example, the amended complaint has a paragraph about Brad Garlinghouse, and it says that Brad Garlinghouse said that XRP and Bitcoin, he doesn't view them as currencies. He said, I don't go down to Starbucks and buy my coffee with Bitcoin or XRP. And so I just pointed out to the judge, some XRP holders view it differently. We do go to Starbucks and buy it on an Uphold card or a global ID card that we actually use our XRP differently. If you have someone, James Rule XRP, and there's others, he's the one that I know of off the top of my head, he gets paid every month in XRP. Yep. So he doesn't acquire all of that XRP for investment. He's got to buy food. He has to pay for gas for his truck, right? He has to pay for everyday life expenses. And so he's getting paid in XRP, and he's using that XRP as a substitute for cash to pay for his everyday living expenses. So that kind of non-investment acquisition of XRP, does Mr. Duty, is he aware of that? That's my first question.
Sure.
Did he consider the fact that 1,700 vendors across the world accept XRP? Did he consider the fact that the UK doesn't consider it an investment contract, that that, all these other things. And so I don't know what his answers were. All I'm saying to the judge is this is one issue that I believe that we have an added view, an added perspective that maybe Ripple doesn't, and that we should be able to have our view and our perspective heard by the court on this issue. That's really the whole thing. You know what I mean? Yeah. At some point down the road, I would seek permission again, even if she denies this one, to be able to participate in the summary judgment motion, right? But what I pointed out to the court was that, I tell you what concerned me the most, Tony, right? And why I felt, even if the judge disagrees with me, why I felt so compelled to do this. When I read the Telegram decision that's in favor of the SEC, where the judge granted an injunction and shut down Telegram, the judge cited Mr. Duty's opinion 7 times in his order. What that means is that Judge Castell in Telegram relied on Mr. Duty's report, and therefore he considered it in granting the summary judgment for the SEC. And so I'll be honest with you, that terrified me, right? Because it's like, wow, like, I'm sure Ripple is, they're great attorneys. They're going to distinguish Telegram from XRP. I know that, but will they say it in a way that is focused on the secondary market the way I will and the way you will, right? Because you got to remember, Ripple has to defend not just today's XRP, but they have to deal with the XRP in 2013, and they have to deal with the 1.3 billion in sales. I'll be honest with you, Tony, I don't care about any of that, right? I don't care. I don't take a position. If the SEC wants to go after Ripple about some specific option contract on XRP in 2013 or 14, and they're going to argue about that, fine, whatever. I got nothing to say. But when you say that the XRP in your mom's wallet, in Tony's wallet, or Tony's mom's wallet, that is an unregistered security with Ripple, when she had no idea who Ripple was when she purchased it, that's just silly, and I'm sure the SEC is not happy with me, but all they had to do, Tony, was say, we're not arguing that the token itself in the secondary market is a security. If they'd have done that, you wouldn't be interviewing me right now, because I wouldn't have anything to say.
Yeah.
You know what I mean? But they're not. And and people have to realize that there's a lot of danger here. If this guy is getting up here, Mr. Duty, and saying that absolutely the only reason someone would acquire XRP is because of something Ripple said, come on, that's not true. And so that's why I felt compelled, to do it.
Yeah, absolutely. And certainly appreciated. And as always, thank you for fighting on behalf of XRP holders, including myself. Something, you brought up with jurisdictions and different regions. I remember in the early days, because there weren't too many fiat on-ramps, I was buying Bitcoin, Ethereum, and XRP on Bitstamp, which is a UK-based exchange. And I was using XRP to move funds to different exchanges because, once again, there was just crypto pairs, not fiat pairs. Does that, play a role, or is it not really significant that, hey, where did you buy your XRP? Because I bought mine from a non-American, if you want to put it that way, the crypto exchange?
No, it's very relevant because also what the court needs to understand, and I don't know how this expert witness handles these. I don't know how much he knows, but do you know how many people that, they would have to buy Bitcoin first, right?
Yeah.
In the early days. And then they would have to try to convert it to XRP on a different exchange.
Right.
And then there were some times that people, they didn't own XRP, but they bought it temporarily to transfer and move it into a different asset. Is that what you're talking about?
Yeah, I did some of that in the early days just because the Bitcoin network was slow and the fees are high. So I used XRP to move funds, then transition it to another crypto. So I did all of that in the early days. This is like 2017, 2018, a bit into 2019 when certain exchanges started adding XRP pairs. It was just faster to do it that way.
Well, that's the point, and that's what the court needs to understand. And I don't know what this Mr. Duty, if he was asked these kind of questions or not. So I certainly don't know that or what his answers were. But this is what is absurd about this. You used XRP as a transfer asset for Bitcoin or Ethereum or some other asset.
Right.
So in that transaction that you used 0.00005 XRP, right?
Yep.
Less than a penny. The SEC is claiming that 10 minutes, 6 seconds, whatever it was that you owned XRP to transfer assets, that's a security, but the Bitcoin's not, that you used it, that the Ethereum's not, that the Litecoin's not, that the Bitcoin Cash isn't. But XRP, that utility token that's used to transfer that cash or that value or that digital asset, that instrument is. And those are the kind of finite distinctions that need to be made. It's why I made the court aware of Spin the Bits, right? Where Jay Campbell, he basically from Spin the Bits developed an app. He didn't like the Lightning Network because you got to be online at the same time and there's risk involved. So he decided to use the XRP ledger to spend Bitcoin. And it's a payment app. So it's called Spin the Bits, which means Bitcoin. Mm-hmm. And imagine that you're moving Bitcoin or spending Bitcoin, but you're using the XRP ledger to do it. And the little bit of fraction of XRP that you're using to move the Bitcoin is considered a security, right? And that it's just absurd. And so the court needs to be made aware of those things. And, everybody is aware of how great and talented and smart that the Ripple lawyers are. But that's the only thing I'm focused on, right? And I want to make sure the court is aware of those things. And so, I can't tell you what the judge is going to say or do, nor would I. But I felt compelled to bring it to her attention, and I'll respect whatever decision she makes.
I know this is a hard question to answer. When do you think you might get a response? In a few weeks or so?
I have no idea. I mean, the only experience I have is with the pre-motion practice. Amicus there's no rules about an amicus. And amicus is usually at the appellate level, the Supreme Court level, at the, the Second Circuit level. It does happen at the district court level where we're at. And Judge Torres has granted in other cases amici status, just like she has to us. Generally, if the regular rules apply, they'd have 5 days to respond, to object to it, and then the judge could issue a ruling there. But it's also possible that she could deny it today, or she could grant it, without hearing what the others say. because it's 100% within her discretion. But I would have to predict that we wait and see if Ripple's going to object or if the SEC is going to object. You know what I mean? And I have no idea. I can't speak for Ripple. I couldn't tell you whether they like the letter or hate the letter. You know what I mean? I don't, you know, people get mad at me because they often ask me, did you ask permission from Ripple to do this? Right. And my answer is no. I don't want to hurt Ripple in any way, but I'm not concerned. I'm concerned about us.
Right.
You know what I mean? I'm not concerned about Ripple.
Now, I did want to ask you about Empower Oversight, Bill Hinman's emails. You know, some of those were released, but heavily redacted. Yep. What are your thoughts on that? And is there a next step or follow-up with regards to those?
No, that's a great question. And we are doing I'm doing separate follow-up. And Empower and I, you know, although I'm a fan of Jason Foster, and although he did on Twitter say that when he learned of what we were uncovering and certain things that I had tweeted, that had led to him to do his own thing, you know, we don't coordinate. And so I don't know what's going on at what stage in the process he is. I can tell you that I know that he sent a referral to the IG, Inspector General, asking for inquiries and investigation into whether or not the speech had been screened for conflicts, right? And we learned that Bill Hinman agreed that he would have things screened for conflicts. And so this speech is a massive market-moving speech.
Yeah.
Think about this, Tony, and your readers, listeners, think about this. How often does Jay Clayton or Gary Gensler or Hester Peirce or Bill Hinman or any other SEC commissioner comment about a specific token? What does Hester say? He says, I'm not going to comment, right?
Yep.
So this one time that someone big up at the SEC, a director of corporation and finance, this one time that they go out on a limb and say, we're not just going to mention Bitcoin, but we're going to say Ethereum is no longer a security, even if it was back when it started. Something of that magnitude that is very different than your normal, we won't comment.
Yep.
I got to imagine, did that get screened? Did someone say, hey, look at this and tell us if there's a problem doing this? Now, I've said that they didn't do it, right? How do I know that they didn't get screening? Because it would be the most incompetent conflict screening in the world. Tony, when someone says, I'm going to give this speech, make sure there's no conflicts of interest. All you do is you look at the speech and go, oh, you're mentioning Bitcoin and Ethereum, and you're saying they're not securities. That's a big deal. Do you own Bitcoin? First question. Do you own Ethereum? Next question. Do any of your family members own Bitcoin or Ethereum? Your law firm, you're still being paid by your law firm, and you're an ongoing profit sharing partner while you're at the SEC. So is your law firm associated with Ethereum or Bitcoin? Oh, wait a minute. Your law firm's a member of the Enterprise Ethereum Alliance? Sorry, Mr. Hinman, you can't give this speech.
Yep.
That's how it would work, right? They might say the SEC, someone else can give this speech,
right?
But you can't, Bill, because you can't even go to dinner with them, Bill, right? Because you're not even supposed to be emailing them, Bill. So if they say to Bill Hinman, if the chief who's on the email, I forget her name now, but she's the chief ethics person, if she says to Bill Hinman, Bill, you are in danger of being in violation of the criminal conflicts laws of the United States by talking to your partners or going to dinner where your partners are. What do you imagine they would say? Oh, you're about to give a free pass to a token that your firm is a member of, and being a member of it means that you're exclusively promoting Ethereum blockchain. Right. It just wouldn't pass muster. And so I can go on record and confidently say two things: that the speech didn't get ethical clearance, right? And two, Bill Hinman, when he's asked, will say, I didn't even know that Simpson Thacher was a member of the Enterprise Ethereum Alliance. And he'll go on to say, it probably wasn't even that big of a deal. But even though it's not a big deal, I didn't know about it. So blah, 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 right? Guaranteed that that's what he's going to do, because, it's so blatant, man. It's so obvious that you just don't do that. And so what we're going to do now is I've drafted some questions that I'm going to ask Warren Davidson and Patrick McHenry and Darren Soto, and on the Senate side, the Senate banking committers, Senator Toomey, Senator Jack Reed. And all we're asking is, will you sign a letter that simply says, we're aware that there's been a referral from this independent Empower oversight. Will you answer those questions? Was there a screening of conflicts? Give us some more information. This is a concern. That's all we want. And so we're going to find out soon if our congressmen and senators are willing to do that. And why wouldn't they, Tony? Like, why not say, hey, this independent government watchdog, who their entire mission is transparency and making sure that there's no unethical conflicts of interest or corruption, they just want to know whether this speech was blessed by the ethics office. Why wouldn't you say, yeah, answer that question?
Right.
When your job on the committee is to oversee the SEC, right? There's just no reason for them not to. I'm not asking them to say anything bad about Ethereum, right? I keep telling people, I know some XRP holders disagree with me, but today's Ethereum's not a security. I agree with Brad Garlinghouse. It's not a security. It was at the ICO. There's no doubt it was, but it's not today. And for the XRP holders who are watching this, who have this instinct to disagree with me, don't fall into the SEC's definition of what a security is, right? They want to say, I reject Ethereum being a security today because I reject the SEC's theory of what a security is, right? And so last time I checked, you can stake Ether, right? And you can use it as collateral. So therefore, just like XRP or Algo or any of the others, you can get a financial benefit independent of the promoters. And so anyways, I know I went off a little bit on a tangent there as far as Ethereum, but I see a lot of people saying, John, I disagree with you that Ethereum is a security. And it was, but that doesn't mean it is today. You know what I mean?
Right. Yeah, absolutely. And it's not so much Ethereum. It could have been Cardano or something else. It's the matter of the SEC and the action they took and their conflicts of interest and so forth. That's the problem, not the asset. It could have been any asset.
Well, listen, I keep trying to tell people, there's a big difference between wanting to hold individuals responsible than to falling into the trap of pointing the finger at a token. Ether's a token, right? And if you don't want to own it because of the way Vitalik or Joe Lubin acted, that's fine. But that doesn't make it a security. You know what I mean? That's all I'm saying. And you have to be consistent. And there are some people who believe XRP was a security in 2013, right? I don't care whether it was or it wasn't.
Right.
It's just not today. And so that's why I try to stay consistent with those.
For sure. Final question here for you, and it has to do with the mounting pressure that seems to be coming at Gary Gensler, more members of Congress coming together, sending him letters and so forth. And just yesterday, we saw Citadel CEO Ken Griffin call him out about regulations. Would love to get your thoughts. It seems like, once again, there's more pressure and it's coming from all angles, whether it be retail investors, media, journalists, and so forth, and then people who are in the industry looking to invest, but they're waiting for clarity.
I think it's a combination of, I think people realize that, although 19,000 cryptocurrencies won't be here 5 years from now, that, there are going to be crypto's here to stay, Bitcoin's here to stay, crypto's here to stay, the ones that have utility and use cases. And I think that, at some point, crypto is going to be a bipartisan issue. And I think whether it's the Ken Griffins or it's the retail, we're kind of getting tired of this Gary Gensler's, he goes, I don't call it regulation by enforcement. I just call it enforcement, right? It's regulation by enforcement. We're tired of you saying everything's so clear, but then you can't give definitions, right?
Right.
And I think what they realize is that, people like the big Ken Griffins, the Citadels of the world, right? When you're in a booming, very liquid economy and the Fed is pumping liquidity left and right and buying assets left and right and interest rates are at zero, you're willing to tolerate certain things maybe because, you're making so much money and things. But when you see what we're facing and bear markets, the stock market, has been down for 8 weeks in a row. Bitcoins went down for 8 weeks in a row. The markets are becoming illiquid. Interest rates are going up. We may be going into a recession. At that point in time, it's like, okay, you need to provide guidance and clarity and get out of the way. Yep. And you're going to go to Congress, you're going to double your enforcement on crypto and go to Congress and say you need more money, right? You're going to go after an exchange saying that they are selling, or a platform that they're selling securities, but you refuse to identify which ones.
Yeah.
You keep telling people to come in, but all they do is leave with a subpoena, right? And I think that it's finally, whether you're a Republican, billionaire, or a socialist, even at some point, you just like, okay, enough of the bullshit, man. Enough of the nonsense. Like, are you going to get with the program or are you're not? And I think that people want him to stop because he's not helping anything.
Right. Yeah, just adding more confusion and ambiguity to the industry.
Yeah. And I think that I've made this prediction that I think Gary Gensler resigns next year because I think he's alienated the Republican congressmen on the banking committee. Like, he ignores their letters, Tom Emmer and them. And I think that if there is a midterm turnover and the Republicans gain the Senate and the House, which it sounds like they will, He's going to be called before Congress, being, in hearings, testifying, trying to answer these questions, because right now it's whoever's in charge dictates the hearings, right? So Maxine Waters is in charge of the banking committee, oversight committee. Right. So she gets to dictate what to have hearings on or not have hearings. When Patrick McHenry becomes the ranking member, he gets to dictate the hearing. So he could say, we want a hearing on conflicts. We want a hearing on cryptocurrency. We want a hearing on this and that. And I think they're going to be getting Gary Gensler up to the hill and grilling them and holding them, responsible for some of this. And I think at that point, he's going to be like, I'm out. Maybe it's wishful thinking.
Yeah, no, but I can certainly see that. And I think we had talked about it. The Biden crypto executive order took the winds out of his sails for a bit. I think because all the agencies are forced to work with each other, and I think they have to put everything on the table. Final item here. Once again, as always, thank you for the work you're doing. Is there anything XRP holders, people in the crypto community can do to help you in your efforts?
The main thing is to not take. You're going to see a lot of people on social media that say it's corruption, it's never going to change, there's nothing that can be done about it, they're only going to get away with it, blah, blah, blah. And if we take that approach, that's what's going to happen. So I would encourage them, if they haven't went to connect to Congress on the Crypto Law US site, all it takes is 20 seconds. Go on there. If you're a US resident, it takes you 20 seconds. You hit the pre-filled message that says, we want an investigation into the conflicts, and their representatives will get a letter from them. And if they're international, go to the international petition that's on crypto site, it's International Connect to Congress, and sign the petition. And we're going to, and I'm very confident, especially with this Empower Oversight referral, that we can get this, right? We can get inquiries into these conflicts of interest. And let me tell you something, once that happens, you're going to see things really start to develop, because there's no way that they can say with a straight face that what was done here is the way it's supposed to be done. And I think that it will lead to an investigation. And I think that once we start, someone has the power, Tony, to subpoena emails and phone records and digital wallet records. Let's find out, who knew what, when. That's all. Did anyone receive the speech, right, before, other than the SEC? Maybe they didn't. And the beauty about what we're asking for is that it's in the SEC's interest. Confidence in the SEC has got to be at an all-time low.
Oh, yeah.
Right. And so whoever takes it over, if Hester Peirce were to become chairwoman, I would say to Hester, order the investigation, because even if the conclusion is this should have been done differently, but there was no criminal misconduct, fine, at least that gets declared, and at least we learn that, right? And if there were some laws violated, then hold those people responsible, and then you gain faith in the institution again. And so I would just encourage people to not give up and not throw their hands up in the air and say, oh, it's a corrupt system and nothing will ever change. Nothing will ever change if we do that. And we can effectuate change. I really believe that.
Yeah, absolutely. And we have the technology, social media, where, we can interact with members of Congress on Twitter. It's a different time, right? And we can crowdsource on the internet where information can't be hidden. We can keep putting it out there. So absolutely agree with you, John. It's always a pleasure chatting with you. Thank you again for all you're doing, and appreciate you joining me.
All right. Thank you, Tony. Appreciate it. See you next time.